Good morning. The, the small employees, bank employees, government employees who are trapped and being dealt domestic inquiry were punished, exorbitant punishment. But if any higher officials, higher bank officers commits fraud, uh, mismanagement, siphoning fund, sanctioning loan without valid papers to third parties are being dealt with good hands. Everywhere these officials were facilitated. But naam ke vaste, for namesake, they used to suspend them and at least just a few days before his superannuation, they will start initiating, facilitating him to approach the High Court and get the orders are being quashed. This is what happening, including CBA also. When CBA start vigilance and anti-corruption cases, some of the higher officials dodged with the CBA or colluded with the CBA and facilitated the culprits to escape from the punishment. Whatever it may be, this is part of our day. But you have to earn much and to spend so that you will be exonerated. Sorry, it's all right. Now I want to share the judgment. AR 2025, Supreme Court 2520. AR 2025, Supreme Court 2520. The judgment is AM Kulshrestha versus Union Bank of India and others. The act which referred in this case was Banking Companies Acquisition and Transfer of Undertaking Act. Then Union Bank of India Officers, Employees, Discipline and Appeal Regulations, Regulation 19. The ratio was, they say, charge sheet against the bank employee must obtain advice of CVC, Central Vigilance Committee. The Central Vigilance Committee is located at Delhi, and everywhere they used to have their branch officers appointing vigilance officers or vigilance committee on every state. But here, even after 34 years of unblemished service, disciplinary proceedings was initiated against the officer. They say then 9 months suspension order. First stage advice was sought from CVC, that was not obtained, and finally they issued. But before the courts, when appellant filed writ petitions before the High Court, they used to take time stating that vigilance officer CVC has to still advise. And they say that the problem was, what was the offense committed by this officer was, he sanctioned a credit proposal 16 accounts by mid-corporate Ghaziabad branch. Thereafter also some similar offences, similar mismanagement, miscreants, similar delinquencies were committed by this officer. Finally, thereafter he filed an application for writ petition for revoking suspension. That was considered, and thereafter the department was facilitated to proceed with the departmental inquiry. Therefore, they straight away issued a circular charge sheet. That was again challenged. This time, after unsuccessful before the single judge and division bench, the Supreme Court says it is duty, if this is the offence or delinquency committed by the employee in bank employees is requires vigilance intervention. So vigilance committees advice should be obtained. Therefore, in the absence of such advice and at the last stage of this superannuation, the charge sheet was quashed, but they did not pay any other benefit except his service benefits. And one more thing is there. See, the question is the purpose for getting advice from CVC was that the allegations are in vigilance angle. Vigilance angle means vigilance officers should inform other bank employees that such and such offences had taken place. So you should be more vigilant in preventing that. That for that purpose only CVC advice is being taken. But even if he gives an advice or not giving advice, in what prejudice was caused to this bank employees, I could not understand. Whatever it may be, but delay is there, and mandatory is, they say mandatory. All these things, okay, understand the procedures, how to get rid of bank employees delinquency and departmental charges. Just